So Keeton lived in New York, and her only connection with New Hampshire was the circulation of a magazine that she helped to produce. And Hustler magazine was actually incorporated in Ohio, but its principal place of business was in California. Its contact with New Hampshire was the 10 to 15,000 editions of Hustler that it sold in that state every month. So what was bringing about this libel suit, right? Keeton was alleging that she was libeled on 5 separate occasions between September of 1975 and May of 1976. Now, these libels included things like a cartoon that falsely suggested she had contracted VD, venereal disease, from her roommate. And then another was a nude pictorial spread of a model that was identified at the time as Keeton, which she obviously denied. Now, it gets to the trial court, only the case gets thrown out, and the court said that the 14th Amendment prevented the use of New Hampshire's long-arm statute to get personal jurisdiction over Hustler magazine. It goes then to the First Circuit for appeal, and they affirmed that lower court decision, saying that New Hampshire's tail is too small to wag so large an out-of-state dog. Basically, New Hampshire doesn't have a big enough interest in what's going on to justify using the court there. They looked at that series of facts that we discussed a little bit before, and they said that the lack of contacts that the claimant has with New Hampshire rendered the state's interest in redressing the libel too attenuated to get the personal jurisdiction over Hustler. And one of the things that they pointed to is something called the single publication rule, which I'm going to be putting up a summary for here. And what normally would happen is that where this rule is applicable in multi-state libel cases, it requires the court hearing the case to award the petitioner damages caused in all of the states if that person wins, even though the majority of the damages are actually happening in the rest of the country rather than in the state where she's suing. The circuit court also made mention of the fact that New Hampshire has an unusually long period of limitation, so a statute of limitations, before libel is no longer actionable. For these particular reasons, the circuit court said that it would be unfair to assert jurisdiction in New Hampshire. Not enough contact, and the statute of limitations is simply too long. And so obviously Keeton sues, it goes up to the Supreme Court, and SCOTUS's response was basically, yeah, no, sorry, First Circuit, you got it wrong. They looked at it, and the Supreme Court said that something like the regular circulation of magazines in the forum state, so where the court is, that the person's trying to sue, is sufficient to support an assertion of jurisdiction in a libel action based on the magazine's contents, even where the single publication rule is in effect. The Supreme Court made it clear that there was a regular sale of magazines in the state of New Hampshire, and because it's regular, it can't then by definition be random or accidental contact. Instead, Hustler is intentionally coming into contact with New Hampshire. They are targeting those citizens. And because they're targeting those citizens, it's unquestioned in the Supreme Court's view that New Hampshire would have jurisdiction over such contacts in the state over a non-resident defendant predicated on minimum contacts between the defendant and the state. The New Hampshire state legislature also went through the trouble of creating a long-arm statute to get at those non-residents. And basically a long-arm statute is a legislative act that lists different ways to get jurisdiction over someone that doesn't live in the state. Because of these two factors, the minimum contacts and the long-arm statute itself, the Supreme Court said that New Hampshire had personal jurisdiction for this issue. Those requirements had been met. Having made that statement, they then go into the analysis, and we look first at minimum contacts. And the court said that this is going to focus on the relationship between the defendant, the forum, and the litigation. It's important that you judge the claim in front of the court in light that damages are being sought for in all states, not just in New Hampshire. So it does have to be fair to compel respondents to defend a multi-state suit in New Hampshire. And in this particular case, the court said that the claim was sufficient to justify that action. They made the point of stating that false statements of fact, so libel, hurt the subject and the reader of this false statement and has the potential to harm the reputation of the person against whom the statement is made, even in places where they've never been, places where no one knows them, places far abroad. The Supreme Court then took another step and they looked at New Hampshire's law itself and made the point that New Hampshire very clearly wanted to protect non-New Hampshire citizens from such behavior. And in making that statement, the Supreme Court pointed to the fact that New Hampshire had explicitly removed the residency requirement for their defamation statutes in 1971. There was also a degree of interest that New Hampshire has in cooperating with other states through this single publication rule to allow for the efficient and effective disposition of cases. It keeps the plaintiffs from having to sue in all 50 states, mucking up the judicial system. That also then has the side effect of protecting individual citizens from things like a drain on their resources, as well as harassment. Somebody sues you for libel in Kentucky, they move next door to Tennessee, then they move over to North Carolina, then South Carolina, the next thing you know, you're in Georgia. And it's just suit. This allows for consolidation, and it protects individuals from being harassed and being drained of their resources unnecessarily. The court also took a slight side note and wanted to remind people of why it was we were here to begin with when they pointed out something interesting. They reminded everyone that the circuit court had stated that it was unfair to apply such a long statute of limitations where other states had already passed theirs in terms of when you could sue. But the court reminded the circuit court in this instance that the issue before it was jurisdiction, not choice of law, and that in fact you don't even get to a choice of law discussion until you've met your jurisdictional basis. And if you've never heard the term choice of law, it's exactly what it sounds like. Which law applies in which circumstance? Is it going to be the law of Ohio, the law of New York, the law of Mars, whatever it's going to be? There are times when you have to determine which law applies in which situation. And just like every other litigation strategy, such as forum, such as litigants, choosing a state with a statute of limitations to your benefit, the court found to be nothing more than another litigation strategy. So then the court looked at, again, the limited contacts portion and found that there was no requirement for minimum contacts with the forum state for general purposes like this. In fact, the exact opposite had been true. They had found instances where jurisdiction was allowed where no contacts occurred. So in this particular instance, for Hustler, he was doing business in New Hampshire. And while the selling of the magazines, those 10 to 15,000 per month, might not be enough to get an individual jurisdiction over Hustler in New Hampshire for other causes of action, in this case, the jurisdiction is actually flowing directly out of the very business activity they're citing. As a result, it's sufficient for this cause of action to pull Hustler into New Hampshire for purposes of minimum contact. And finally, the court took one last swipe and found that there was no justification in trying to restrict a libel action to the plaintiff's home forum, rather than allowing them to sue elsewhere. So the victim of a libel, like every other tort, may choose to bring suit in any forum with which the defendant has certain minimum contacts, such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice. In this case, the court is applying the facts and said that Hustler had deliberately and continuously exploited the New Hampshire market and must reasonably anticipate being hailed into court there then in a libel action based on the contents of its magazine. Basically, Hustler opened the door when they decided they wanted to sell in that market. The end result was it was remanded back down due to this new jurisdictional finding because the Supreme Court said she had personal jurisdiction. Hustler could be sued in New Hampshire. So what's the end result of this particular case? There was a finding in favor of Keeton, and Hustler had to pay $2 million in judgment as of August of 1986. So I hope that all made sense and that you enjoyed the particular video. Long-arm statutes, personal jurisdiction, it's a lot and it can be kind of dry, but why not? Let me know what you think of the case down below. Have you read the actual decision? Did the court get it right? If not, why not? I'd love to know what you think. But until we're all together again, I hope everybody is well.